A writ of mandamus is an order from a court to an inferior government official ordering the government official to properly fulfill their official duties. In this case, lawyers for members of the YSL group, who are on trial by the state of Georgia for RICO-related charges, are asking the state's Supreme Court to force the judge in the case, Glanville, to step down. Some citations have been omitted for the flow of this audio production, but can be found on the official document. Comes now. Diamante Kendrick, petitioner, by and through his undersigned counsels, and brings this emergency petition for writs of mandamus and a stay of proceedings, showing as follows. 1. Jurisdiction and explanation of emergency nature of petition. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville, and not to any rulings or orders of the judge. This court has jurisdiction over this matter under citation omitted. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective movants. Likewise, Glanville has denied the movants' respective requests for a certificate of immediate review 3 times. Glanville, as Chief Judge, has obstructed defense counsel's attempts to have a disinterested party review the numerous allegations contained in at least 4 affidavits which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance in refusing to provide a transcript of a secret, ex parte proceeding, Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded, Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for abuse of discretion. Glanville's obstruction of defendants' right to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied, and 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any effort to file a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of action. Glanville's court is where writs go to die. As the present petition for writ of mandamus would go to Glanville if filed in Fulton County Superior Court, petitioner has no option other than for the Georgia Supreme Court to exercise its discretion and consider defendants' claims. A secret ex parte proceeding was held on June 10, 2024. In attendance were Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceeding on June 12, 2024, petitioner requested that the presiding judge, Glanville, recuse himself from petitioner's trial for, among other counts, Count 2, murder. Citation omitted. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25.3. Glanville denied a request for a certificate of immediate review. A formal order denying the motion was entered on June 14, 2024, 2 days after the motion for recusal was filed. As Chief Judge of the Fulton County Superior Court, Glanville holds a unique position within the county which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writs is petitioner's only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in the case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as the coercive joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland. 2. Relief sought. As Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that if proven would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. Petitioner further asks of this court that proceedings in the trial in 22 SC 183572 be stayed pending resolution of the motion for recusal. Petitioner further asks this court for a writ ordering Glanville to produce immediately, and certainly no later than prior to the start of cross-examination of Copeland, an unredacted transcript to defendants of the secret ex parte proceeding held on June 12, 2024. Petitioner also asks of this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. 3. Issues presented. Whether Glanville was correct in failing to follow the mandates of USCR 25.3 by refusing to refer the motion for recusal to an unbiased judge for hearing following argument on June 12, 2024, particularly after making findings in an order of June 14, 2024, that the motion was timely, the attached affidavit was legally sufficient, and that the affidavit contains assertions of fact to support the allegations of bias and impartiality. 4. Statement of facts. A. Procedural history. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State v. Diamante Kenrick, et al., 22 SC 183572. Jury selection took more than 10 months with trial before the selected jury beginning November 2023. Following the secret ex parte proceeding on June 10, 2024, petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein, Exhibit A, to Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied instanter with a formal order issued on June 14, 2024, Exhibit B. B. The secret ex parte proceeding. A central figure, perhaps the central figure, in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. On Friday, June 7, 2024, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the Fifth. C. XDA Weinstein Affidavit P1. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10, 2024, at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of defense counsel, an ex parte proceeding was held in Glanville's chambers on June 10, 2024. Among the attendees were Glanville, Ada Love, Ada Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of the trial. Neither Glanville nor any member of court staff nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. One or more members of defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor from the DA's office. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than testify. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Glanville working in concert with the 1 or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Upon information and belief, sworn witness Copeland stated to Ada Hilton that if called to testify, he would simply lie on the stand, important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand, important Brady material that has yet to be provided to Kendrick. Upon information and belief, sworn witness Copeland also stated to Ada Hilton that he would testify that he killed Donovan Thomas Jr., important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to sworn witness Copeland stating to Ada Hilton that he would testify that he killed Donovan Thomas Jr., Ada Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas, important Brady material that has yet to be provided to Kendrick. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through her counsel, filed a motion to quash order to show cause and motion to recuse, attached as Exhibit D, on Friday, June 14, 2024, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus's first-hand account of the misconduct is credible. The facts Attorney Bumpus asserts are as follows. On Monday, June 10, 2024, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify. Those present for the substantive portion of this ex parte proceeding were Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court's security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter, ID. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to reassert his Fifth Amendment privilege. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. Copeland cautioned that his testimony would be a lie. See events in court about the time of the secret ex parte proceeding. On Monday, June 10, 2024, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m., admitted entrance into courtroom 1C, and seated within by 9 a.m. Exhibit A, Weinstein Affidavit. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempts to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, citing Rule 1.6 of the Rules of Professional Conduct, Glanville held Steele in criminal contempt and sentenced him to 20 days of incarceration. D. Glanville's hearing on the motion to recuse and subsequent order. On June 12, 2024, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings. Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10, 2024, secret ex parte proceeding was 1. In violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing, and 2. In violation of Rule 211A in the revised Georgia Code of Judicial Conduct that says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. During the June 12, 2024, hearing on the motion to recuse, Glanville refused to conduct the timely analysis required by USCR 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Weinstein requested at that time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated that an appeals court could look at his denial at the conclusion of trial. On June 14, 2024, Glanville issued an order on motion to recuse Chief Judge Glanville, attached as Exhibit B. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by USCR 25.3. The court found all three prongs of Rule 25.3 satisfied, and the analysis should have stopped there. But Glanville did not. Applying the wrong standard and reaching the wrong conclusion, Judge Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. This was the first of three motions to recuse denied by Glanville. 5. Argument and citations to authority, A. Standards for granting writs of mandamus under, citation omitted. This court has those powers necessary in aid of its jurisdiction, including the power to issue process in the nature of mandamus and injunction. OCGA, Paragraph 9-6-20, allows parties to seek mandamus to compel a due performance of official duties where a defect of legal justice would ensure from a failure to perform or from improper performance, and there is no other specific legal remedy for the legal rights. To compel removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. To preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. Blaylock v. Cartwright, 300 Geptree 884, 2017. B. Glanville has failed to follow the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, The judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. Glanville failed to follow USCR 25-3 during the hearing of the motion to recuse on June 12, 2024. Glanville, following filing and presentment of the motion to recuse on June 12, 2024, failed to make the required determinations under USCR 25.3. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court instead of recognizing it as a list of incidents of judicial misconduct by Glanville. Glanville curiously clings to Baptiste v. State as supporting his contention that the Weinstein affidavit does not merit recusal, but there is no support in Baptiste for this position. In fact, Baptiste supports Petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. Glanville failed to follow USCR 25.3 in his order of June 14, 2024. Glanville's order of June 14, 2024 contains a critical error of law. The law requires that when making a determination under USCR 25.3, the court must consider whether recusal would be warranted, assuming any of the facts alleged in the affidavit to be true. A judge is not allowed to pass on the truth of the allegations in the affidavit. Instead, Glanville properly found that the Weinstein affidavit contains assertions of fact to support the allegations of bias and impartiality, Exhibit B, P. 5, which by law should have ended his inquiry. Glanville must then refer the recusal motion to a neutral judge to decide the merits of the motion pursuant to USCR 25.3. Glanville's factual review of the Weinstein affidavit is particularly astounding given that Glanville has repeatedly refused to give defense counsel access to a transcript of the secret ex parte proceeding. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of our source and to issue an order to show cause to attorney Kayla Bumpus in an attempt to silence her. While Glanville's views appear to be evolving over time, Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. However, at this point, Glanville is still indicating that any transcript provided will be redacted to remove privileged information. What could be privileged in a proceeding among Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. Glanville failed to follow USCR 25.3. Proper procedure requires referring a motion to recuse to an unbiased judge after the three prongs of Rule 25.3 have been met. C. Glanville has violated multiple rules of the Georgia Code of Judicial Conduct. Chief Judge Glanville's secret ex parte proceeding violated at least USCR 4.1 and J Code of Judicial Conduct 2.9 and 2.11a. The facts alleged in the Weinstein affidavit, Exhibit A, must be assumed true when deciding whether recusal would be warranted. See USCR 25.3. The details learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person a fair hearing. Ex parte communications are presumed to have been in error. City of Pendergrass v. Skelton, 628 SE 2D. Not only did Glanville fail to notify defense counsel about the ex parte proceeding as required by Rule 2.9, but Glanville made every effort to conceal the proceeding. As attorney Lester Tate states in paragraph 14 of his affidavit in Exhibit C, in reviewing the video of the exchange between Judge Glanville and attorney Steele, there was no disclosure of the ex parte proceeding, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, He sought to keep others from disclosing and to punish those who might already have disclosed. Georgia Code of Judicial Conduct, Rule 2.11 (a) says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Mondi at 75. The facts must be considered from the perspective of a reasonable person rather than from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. Wynn v. State, 228 S.E. 2d. See also Benton v. State. As this court wrote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyer. Johnson v. State, 278 GA 344, 602 SE 2D, 623, GA 2004. Defendants were not provided notice of the hearing. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage 8 of the trial is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness into testifying. As the motion to recuse met all requirements of USCR 25.1, USCR 25.2 and 25.3, Chief Judge Glanville must assign the motion to recuse to another judge for consideration on the merits. 1. Glanville's failing to follow USCR 25.3 violated at least GA Code of Judicial Conduct 2.1 rule. 2.1 of the GA Code of Judicial Conduct reads that judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. In the hearing of June 12, 2024, Chief Judge Glanville failed to follow USCR 25.3 by failing to make the determinations required in a timely fashion. Petitioner need not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12 and June 14, were a violation of Rule 2.1 of the GA Code of Judicial Conduct. 4. Conclusion. Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. As Attorney Tate writes in paragraph 15 of his affidavit in Exhibit C, here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to ensure a fair hearing, and who, also, has actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality and, assuming it to be true, would require recusal. Again, I reach this conclusion based on Judge Glanville's actions, not any ruling that he has made in the course of this trial. Petitioner requests this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted transcript to defendants of the secret ex parte proceeding. Petitioner further requests that proceedings in the trial in 22 SC 1-3572 be stayed pending resolution of the motion for recusal. Petitioner also requests this court enter any further writs or orders it deems appropriate, given Glanville's actions. This the 20th day of June, 2024. This submission does not exceed the word count limit imposed by Rule 20. Douglas S. Weinstein, E. J. Abt, Katie A. Hingerty.